How much do you hate robocalls and marketing text messages? Welcome to another episode of A Little Privacy, Please. I'm Jenny Holmes, and with me is my co-host, Jason Kravitz. Together, we lead Nixon Peabody's privacy and cybersecurity team. Today, we have a very special guest, Troy Lieberman, who is the Vice President of Legal at Attentive, the leading text message software platform. Troy is responsible for the product counseling, compliance, privacy and security, litigation, IP, and public policy functions. So let's just start with the basics. What is the Telephone Consumer Protection Act?
In short, the TCPA, or Telephone Consumer Protection Act, is a federal law that was passed in 1991, largely in response to a flood of telemarketing calls in the late 80s. It regulates automated calls, pre-recorded calls, text, and faxes. Importantly, though, in 1991, there was no texting, no unlimited plans. Different marketing technology was in use. It was an entirely different landscape. And what you're having today is a 1991 law being applied to modern technology. It's enforced by the FCC and the FTC, but also includes a private right of action where individuals can sue for up to $500 per violation. And there's no cap, making it a class action target. The TCPA and related regulations also include the Do Not Call registry and the so-called quiet hours prohibitions about when telemarketing cannot occur.
So Troy, as you just mentioned, there's been a lot of class action litigation involving the TCPA. Can you give our audience a little bit of sense about how that's evolved over time?
Yeah, that's right. It's definitely a cottage industry of class actions under the TCPA. Largely came about as a result of an FCC order in 2015, which made the TCPA more consumer friendly. Just by way of example, in 2008, there were 14 TCPA lawsuits in federal courts. There were over 5,000 a decade later, so it's really exploded. Fortunately, in 2021, the Supreme Court issued a decision in a Facebook case, significantly narrowing that 2015 FCC order. But it's important to note that really only dealt with the auto dialer definition, and we're still seeing a lot of litigation around what is an auto dialer. It also had no impact on those pre-recorded or fax litigations that also seeing. And so plaintiffs' lawyers have run with this, and under the TCPA are asserting claims and class actions. And many of them may have merit, but most are calculating that the cost to defend these, even a frivolous suit, is not worth it to defendants, and are extracting settlements as a result.
In my experience, the TCPA has some sort of got ya provisions. What are you seeing plaintiffs' lawyers really highlighting as main violations of the TCPA?
Yeah, I mean, there are a lot of technicalities in the TCPA and the related regulations. For example, what constitutes an auto dialer? What constitutes valid consent? For example, there's differing levels of consent for the different types of communications, transactional or marketing. The type of technology used, auto dialed, pre-recorded faxes, all can impact the level of consent. And so, missing one small aspect, such as leaving out a key phrase in the consent language, can be incredibly costly. While there are some defenses, if you miss one of the key requirements of the consent language, it's essentially a strict liability statute, and plaintiffs are willing to pounce on that. And that's really one of the biggest issues under the TCPA, in my opinion. Spam calls are on the rise, and those are truly spam calls with bad faith actors. But where the TCPA comes in is plaintiffs' lawyers are looking for the low-hanging fruit. They're going after the legitimate companies whose consumers generally do want to hear from them and have opted in to receive these messages. But because they miss, don't dot an I or cross a T in the language, they're the ones facing the lawsuits, and the truly bad actors who are doing scams and other things that are harder to find and track down are running unabated, and the TCPA really is not set up to function to deal with the largest issue out there.
So Troy, TCPA is obviously a federal statute, and I know that some states have what are called mini TCPA statutes, like in Florida. Do companies need to be worried about the state law level as well?
Absolutely. And the Florida one, especially, as you mentioned, Jason, came about in direct response to that Supreme Court Facebook decision. Florida amended their laws to revert kind of to the pre-Facebook decision, at least for the state of Florida. They've also added some quiet hour limitations and limiting 3 communications per 24 hours on the same subject matter prohibition. So it definitely is more onerous. And a huge amount of litigation in the last 2 years has been based in Florida as a result of the more favorable conditions for plaintiffs' lawyers. But fortunately, the Florida legislature just amended that law. It's waiting on the governor's signature, and we are optimistic that it will significantly curtail litigation. There still will be some, and it's still a concern, but hopefully less so than it has been. But other states have followed Florida's lead. New York, Maryland, Washington, among others, have either passed or introduced very similar legislation. So the state law levels are certainly a concern. We're monitoring that on our end, and everyone should be at least aware of what's going on at the state level.
So I think it's safe whether you like this title or not, but you are a TCPA expert. Any pieces of advice for businesses trying to navigate the landscape that is the TCPA?
I appreciate that title. It's definitely a difficult landscape given uncertainty both at the federal and state level, and obviously significant penalties for running afoul of them. The best practice that can really mitigate risk significantly is getting consent. Getting sufficient consent to use automated or pre-recorded methods for marketing purposes goes a long way to mitigating your risk. Obviously, other things like honoring opt-outs are certainly important, but consent is really detailed and important. And if you do that right, that goes a long way. And almost as important as getting the right consent is retaining proof of consent. So when push comes to shove and a consumer files a complaint or makes a demand, you can show them the exact language that they saw, the exact opt-in that they agreed to show that they agreed and consented to what you are doing as a business. Obviously, I'd be remiss not to include that working with experienced counsel to help navigate this is a great thing. Using established vendors who know this space and can give a guiding hand is also important because it is so fraught with landmines for unexpected companies.
Troy, thank you so much for taking a little bit of your time to help us understand the TCPA better. Appreciate it. Great to see you, and join us again next time for another episode of A Little Privacy, Please. Is it true, Troy, that you wanted to name your daughter Autodialer?
That is completely false, but we wanted her initials to be ATDS.